Thank you very much, Acting Speaker. And it's a pleasure to rise today on the Justice Legislation Amendment Bill 2023. And I'd like to start by thanking the Shadow Attorney General, the member for Malvern, for his contribution this morning. And as he noted, this is a piece of legislation that we will not be opposing, as it does provide a relatively large range of uncontroversial fixes to a number of pieces of justice legislation aimed at improving the operation of our justice system as a whole. And I think we've heard contributions from both sides of the House today speaking to the importance of making sure we have a justice system that is operating for Victorians, a justice system that is operating efficiently. And many of the amendments outlined in this bill for the various pieces of legislation it seeks to amend will make it a simpler process, a more transparent process in many cases, and a clearer process as to what are the responsibilities and the requirements of those operating in the space. The bill itself seeks to amend a number of pieces of legislation, seeks to clarify pieces of legislation, including the Open Courts Act, looking at alternatives to physical court hearings. It seeks to amend the Coroners Act, the Spent Convictions Act, regarding the facilitation of information sharing and access. And as we've heard a number of members speak about, it does seek to amend the Firefighters Presumptive Rights Compensation and Fire Service Legislation Amendment Reform Act around expanding the presumptive rights scheme to include three additional cancers under that piece of legislation, and making sure that as we see the growth in the number of female firefighters in Victoria, that we are ensuring that the legislation keeps pace with that. And I'll speak more broadly about that a little later. It also seeks to amend the Legal Profession Uniform Law Application Act, the Children, Youth and Families Act 2005, looking at how electronic case management can be deployed in that space. The Jury Directions Act, around a number of important changes around sexual offence cases. The Criminal Procedure Act 2009, looking at who may witness statements in briefs. The Victorian Civil and Administrative Tribunal Act, the Wrongs Act and the Limitation Acts, and the Domestic Building Contracts Act regarding recent court decisions and how making sure that the federal issues can play out under VCAT and other judicial bodies. And the Crimes Act 1958 around looking at Victorian Aboriginal legal services and contact in all cases where a person is taken into custody who identifies as Aboriginal, and the Victoria Police Act 2013 regarding correcting error in previous amending legislation. To touch on some of these briefly, under the Open Courts Act, the changes make permanent a number of measures that were due to expire in October this year that were put in place during the pandemic, and these include the power to require compliance with pandemic orders made in accordance with the Public Health and Wellbeing Act 2008, and regarding the fact that authorised officers can exercise those powers beyond pandemic orders to ensure compliance with health and safety obligations to court employees and court users. And essentially, the provisions will mean that in the event of a future pandemic, court officers will be empowered to enforce not only the relevant pandemic orders but also measures necessary to safeguard the health and safety of court users. And we know that during the pandemic, Acting Speaker, courts still had a role to play. We know that many courts were able to shift to online to help the facilitation of the justice system continue during that time, but the backlog caused in that has had a long-term impact on our justice system, and something that continues to this day. The amendments relating to the coronal investigators, this looks at giving explicit power to a coroner to direct coronal investigations at all stages of an investigation, and imposes a duty to comply with reasonable directions of the coroner. It makes clear that the coroner is directing the coronal investigation rather than relying on the current arrangements, which are currently convention with the police. So it puts in place clearer directions, and the coroner will be responsible for that. The amendment of the Spent Convictions Act seeks to remove unintended barriers to spent convictions by narrowing that definition from term of imprisonment to custodial term, Acting Speaker. And the custodial term does not include drug rehabilitation, home imprisonment, intensive correction, residential treatment order, or any part of the term that was suspended or elapsed without being served. And for youth offenders, this bill removes the requirement that children and young offenders must be sentenced under specific legislation in order to be eligible to have convictions spent. Acting Speaker, I spoke briefly before about the changes to the firefighters' presumptive rights compensation legislation, and the original purpose of this bill was to provide a rebuttable presumption to claim compensation under Workplace Injury Rehabilitation and Compensation Act for career firefighters and volunteer firefighters who are suffering or will suffer from specified forms of cancer. And this is to ensure that there is more equitable access to cancer compensation for eligible personnel and remove barriers to that compensation. And previously, it's been difficult, Acting Speaker, to prove a particular event or exposure caused the development of that cancer due to the significant number of incidents that our brave firefighters respond to throughout their careers. And the expansion of the presumptive rights recognises the invaluable service that firefighters and personnel provide to our community. I know everyone in this place is very proud of the work that their local firefighters do, that the CFA does in times of need, particularly over the summer months and the peak bushfire seasons. And the expansion of this presumptive right for 3 additional cancers under this piece of legislation will particularly ensure that female-specific cancers are listed, and the additional 3 cancers will impact female firefighters, particularly to include cervical, ovarian and uterine cancer. Acting Speaker, the amendments to the legal profession, we heard from the member from Elwood Park, the process that you go through when you are admitted as a lawyer and the duty that you undertake to the court and to the client and to the legal profession more broadly. And this amendment seeks to ensure that there is a 28-day time limit for appeal or review of disciplinary action, and this means that the Victorian Legal Services Board will be able to publish any details of a determination on unsatisfactory professional conduct on the register of disciplinary action after this time has elapsed. And the bill clarifies that the offence of causing a deficiency in trust and the improper destruction of a regulated property are indictable offences and that they will be triable summarily. And it's incredibly important that there is trust in our legal profession, that people are able to ensure that when they are looking to seek representation, looking to seek the undertaking of a lawyer, that they are able to trust that lawyer, and this piece of legislation will go further there. Acting Speaker, a few more important amendments around the introduction of electronic case management under the Amendment of Children, Youth and Families Act. This will allow for the electronic filing and issuing of documents, creating a more efficient system. And the Amendment of the Juries Act, looking to clarify that certain jury directions are available in all sexual offence trials, regardless of whether the prosecution is required to prove a lack of consent. And this seeks to remedy errors made in 2002 when the jury's directions were worded in a way that was unnecessarily referenced to a lack of consent. So seeking to amend a previous change to the legislation and ensure its proper reading within this omnibus bill. And then looking at a number of changes, particularly around VCAT-related amendments that have come about as a result of recent court decisions that held that VCAT has no power to hear matters that involve the exercise of federal jurisdiction, including matters where there is indirect connection to federal law. And this has potentially invalidated a number of VCAT decisions and required the referral of matters initiated in VCAT to courts that can exercise that federal jurisdiction. So these reforms will expand the class of VCAT members who can make orders to transfer to the federal jurisdiction and provide courts with the power to extend the limitation period for federal jurisdiction matters referred to them by VCAT. So this is an important change that will affirm that VCAT holds power previously assumed by VCAT and the legal profession, and applies more broadly around the Domestic Building Contracts Act as well, which is very important given we've seen a number of ongoing issues in the domestic building industry. So, Acting Speaker, the opposition does not oppose this bill, and we appreciate the number of reforms it seeks to undertake.
The member for